Welcome. Today, we'll delve into the crucial preliminary stages of a large-scale jury trial in New Zealand. These steps are vital to ensure fairness and minimize the risk of a retrial. Here are some key suggestions for managing these preliminaries. Sound system. In crowded courtrooms with large jury panels, a sound system may be necessary to ensure jurors can hear and understand the judge during the empanelling process. Instructions on interest. Instructions regarding any interest or knowledge in the case should be given immediately before empanelling begins. These instructions can be repeated after the 12th juror is empaneled, but before the jury is sworn. Counsel should be informed of this in advance. Witness details. The judge may delay giving the jury details of witnesses until the 12th juror is empaneled, as jurors may not absorb these details earlier. This depends on specific circumstances, such as high-profile trials where jurors might know the witnesses. Witness lists. Where there are many witnesses, the Crown can provide a list of their names and occupations. This list can be distributed to the jury before it is sworn. The defense may also supply a list. Explanation and comfort break. The judge may explain why the preliminaries are taking time and offer a comfort stop for the jurors. Jury swearing and foreperson selection. Once interested jurors are eliminated, the jury is sworn and retires to select its foreperson. The judge emphasizes the importance of selecting a competent foreperson, especially in a lengthy trial. Expanded preliminary remarks. The judge gives an expanded version of the usual preliminary remarks, including sitting hours and challenges related to their duties over a long trial. Before empanelling, the judge's role includes recording appearances by counsel, ensuring charges are properly put to the defendant, pleas are recorded, and self-represented defendants are aware of the trial process. Before empanelling, the judge explains the process. Jurors hear their name called and sit in the jury box. They must be available every day, speak and understand New Zealand English, and not know anyone connected with the trial. This is what happens during the empanelling process. A juror's name is called. Challenges are signaled before the juror sits down. 3. This continues until 12 jurors are seated. The jurors are sworn in. The jurors select a foreperson. The remaining panel members are kept in case they are needed when a juror indicates an issue. If a juror has an issue, they approach the judge for a quiet conversation. The judge either excuses the juror or determines they should sit. The judge also inquires of defense counsel whether there will be a defense opening statement. Selection of foreperson. The jury selects a foreperson, who acts as a chair and intermediary. The foreperson ensures the jury carries out its duties properly, follows directions, and communicates with the judge. The judge advises the jury on the foreperson's role and qualities to look for. There is no time pressure on this selection. Judge's preliminary remarks. The judge addresses routine housekeeping matters, the presumption of innocence, and the Crown's burden of proof. They may also introduce the case in more detail, depending on its complexity. The judge covers court procedures, including introductions, seating plans, transcripts, pretrial publicity, and jury conduct. Jurors are directed not to undertake their own inquiries or experiments, and to disclose any extraneous information. Jury members must not undertake own inquiries. The Contempt of Court Act 2019 prohibits jurors from conducting their own investigations. The juror's oath also explicitly prohibits this. Jurors are directed to disclose any extraneous information they receive. This ensures a fair trial. These preliminary steps are essential for a fair and just trial. By following these procedures, the court ensures that the jury is impartial, informed, and ready to fulfill its important role.